Fact riot cases. Why are police not penalized in India? This article is published in Times of India 21st September 2025, written by Sri Swaminathan S. Anglisarya Iyer. I thanks to Swaminathan sir and Times of India. 5 years after riots in northeast Delhi, justice has not been served. It has been weaponized politically. On one hand, dozens of activists languish in jail for years without trial, denied bail under draconian laws like the Unlawful Activities Prevention Act. On the other hand, in case after another, the court lambasted the police for artificial witnesses and fabricated evidence. Media investigation have highlighted these damning comments. The court say the police have sought to create crimes where there are none, thus committing what can only be called crimes themselves. Why are court unwilling to jail the police for perjury and subverting justice? Why is harsh legal action reserved for those who have never been convicted, sometimes not even tried, while leniency is reserved for those castigated by courts themselves? If policemen know that the courts will not penalize them for lies and fabrication, no one will ever stand up to political pressure from above to make charges and seek conviction by hook or crook, not due process of law. Trial courts have repeatedly torn apart police investigation in the Delhi riots. Out of the 116 riot cases decided so far, more than 80% have ended in acquittal or discharges. In at least 17 acquittals, the language used by judges has been damning. Only the naive can believe that so many fabricated and hollow prosecutions arose merely from police incompetence. This was not just bungling. Was the real target the rioters or the protest movement against the Citizenship Amendment Act, which had the potential to make many Muslims stateless? Unlike most Muslim agitations, the Shaheen Bagh protest was not led by mullahs or politicians, but by local housewives, overwhelmingly Muslim, who blocked a road peacefully. It was strongly supported by students from nearby Jamia Millia Islamia. The protesters swore by the constitution and had large posters of Gandhiji, Subhash Chandra Bose, Bhagat Singh, Nehru and Ambedkar, the makers of the constitution. They lit a fire of democratic defiance that spread to cities across India. Unable to erase Shaheen Bagh legacy through democratic debate, the state chose to discredit it through criminal prosecution, claiming that it was orchestrated by anti-Indian elements. The larger conspiracy case against several of the activists was not so much about genuine security threats as it was about turning a movement for equality into an act of sedition in the public eye. While student leaders and women protesters were put behind bar for 5 years without bail, politicians who openly incited hatred with chants such as "Desh ko Gadaran ho, you can complete the slogan yourself," faced no legal consequences. Some sought to demonize upholders of the constitution as anti-national, Pakistani agents or worse. Yet none of them was even seriously questioned. Through inaction, the court have become complicit in this double standard. Judges cite the seriousness allegations against the protesters but ignore the fact that these allegations have been made by the very police investigators that court described as hollow, fabricated and partial. Activists are jailed because the charges are serious, but the charges are serious because activists are accused, not because evidence is conclusive. The Supreme Court repeatedly says that bail is the rule and jail is the exception, yet refuses to enforce this in UAPA cases. What is the way forward? First, the court must reclaim their spine. Once they would come down hard on misuse of the law and double standard. But in the last decade, the court have tilted too strongly towards the executive. Refusal of bail is understandable to check terrorism, but classification of activists as terrorists must be treated with skepticism. Arrest of activists should take place only when convincing evidence is available. If trials have not begun within a year of arrest, bail should be granted. In such cases, arrests have simply been devices to jail inconvenient people. Bail must be restored as the norm when trials are delayed. Second, police misconduct must be punished, not excused or glozed over. Investigation that collapse in court should trigger accountability, not impunity. Third, the force of draconian laws like UAPA must be subject to serious limitation by court. No democracy can survive when the mere accusation of terror or treason can erase right indefinitely. India must take if it seeks to be a true democracy. Bible talks about police atrocities in India in Ecclesiastes chapter 5 verse 8. If those seized the oppression of the poor and violent perverting of judgment and justice in a province, marvel not at the matter, for he that is higher than the highest regard, and there be higher than they. Amen.